Our colleague anchor Oliver Dixon is now ready to engage. A very good morning to you yet again, Oliver. It's the breaking news this hour. The president having succeeded in his litigation to bring the Section 89 committee to a halt pending that report review.
Yeah, no, certainly in a staggering order that has been handed down, split three ways across the bench, but with the third judgment concurring with the second judgment. The court has ordered that President Ramaphosa has made out a case for an interim interdict to be granted, and that the first and second respondents, that is to say Parliament and the committee, are prohibited from going forward with it's very specific language, a public impeachment hearing. That's what the language of the order says. That seems to not preclude any other work that the committee might want to do in the background. That is to say, the appointment of an evidence leader, the deliberation on the terms of reference. And I mention that because today is the deadline for parties, the 31 members of the panel, to submit to the committee their consideration on the terms of reference and other matters such as the appointment of the evidence leader is yet to be considered at the next meeting that will be taking place. Now, the court has not yet substantiated on its reasons. Therefore, the presiding officer did say that the judgment will be made public, and we can then look into why the court had made the order that it did. But yeah, it is a split decision there in the court. Unsurprising, really, given just how contentious the legal considerations here are.
However, it feels the attention is going to move to that review application that the president is now anticipated to make in September. And if the arguments that were made during hearings for this interim interdict are anything to go by, we do kind of have a sense of the direction he's likely to take, because at that stage he had mentioned that he believed that this report was flawed. It was the panel had misconstrued its mandate, and in fact it had acted irrationally.
Yeah, one of the considerations that the Ngcobo panel had made was on this question on whether or not the president was engaged in other work, so to speak, which, of course, is precluded. The public protector, interestingly, investigated just that question, and the public protector found that given that the Phala Phala farm had generated no profit and that the president had no financial benefit from it, he therefore was not engaged in other work. And of course, that is a departure from what the Ngcobo panel had, at least as a preliminary finding, had stated in its report. Now, of course, that will have to be considered by the review court. Another matter that the review court, and the more substantive matter that the review court will have to consider, is whether or not there was a misapplication of the evidence of law. In the law of evidence, rather, in this instance. That is to say, whether or not it met the threshold for what could be considered admissible evidence. Given that the court, that the Ngcobo panel did not have the powers to subpoena in the way that a commission of inquiry might have, right? And given that it had to rely entirely on those who volunteered information to it, such as Arthur Fraser, it had very limited scope in terms of what it could assess and how far it could assess that. It did make attempts to externally corroborate that which was placed before it, but of course that came with limitations, not just of time, which they had 30 days to do this, but also of resources. And so the review court will have to consider that. Another thing that the review court will have to consider that the interim interdict court just now had left for it is the cost consideration. Of course, you know, cost arguments are a standard part of litigation, particularly where it is highly politicized. And of course, the court said it will not give an order or consideration on cost, and it will leave that for the review application.